Welcome, Jason Downs, to our Ripple Tech Conversation series. And we're so happy to have a real-life law enforcement officer here with us. And so let me just quickly introduce you and we'll dive right into our conversation. Jason Downs serves as Chief Deputy Attorney General for the District of Columbia. He is now a prosecutor, law enforcement officer, has been a law firm founder and a public defender. So just really quickly, let me just run through that so that our audience will sort of get where you're coming from, Jason. So in his current job, Jason works on behalf of DC residents to stop deceptive and unethical business practices and has taken on tech giants like Facebook, Meta, and Amazon over issues such as privacy, antitrust, and misinformation concerns. And that's something I hope we'll get to, is sort of how misinformation concerns fit into a consumer protection framework. The office is also working on local legislation to combat discrimination and prevent algorithmic bias in automated decision-making, impacting everything from loans to jobs to healthcare to housing. Jason was a founding partner at Downs Collins, where he handled high-stakes civil and criminal litigation in the district and nationally. He also spent nearly a decade at the Public Defender Service for DC, where he served as the training director. And you can see by his unlined face that he must have been one of the youngest lawyers in PDS history to have served in that capacity, and indeed he was. And Jason also undertakes work that many in our community undertake, which is to talk to high school students about pursuing a legal career. So Jason, thank you for being with us. And I guess let me just start out with a sort of big framing question, which is that, we're seeing perhaps in light of sort of federal paralysis on the issue, an increasing amount of action in the states and the District of Columbia around enforcing consumer protection laws, especially when it comes to tech and tech abuses. And so I just hope you can, tell us a little bit about how that works in DC and how your office approaches the issue of abuse of tech power.
Absolutely, Ellen. Well, first, I should say thank you for that overly kind introduction. Very much appreciate it. And I'm really grateful to Rutgers for hosting this series of conversations. It's a really, really important series. I've had the opportunity to view a few of the previous conversations that you've had, and they're excellent. And I'm just honored to be a part of this series. So thank you for having me, Ellen. And okay, in the District of Columbia, I should start with saying that our office is quite unique in that we are different from many other state AG offices. For starters, the independence of our office is relatively new, right? So back in 2010, the DC voters overwhelmingly approved or voted for a charter amendment to transform the Office of Attorney General in DC into an independent office, which means that the AG would be decided by voters, not someone appointed by the mayor. And notably, that independence also came with a mandate to bring affirmative litigation in the public interest to protect vulnerable residents, hence our consumer protection mandate. So another sort of unique thing about the District of Columbia is that because we're not a state, we are, if you will, split. Our prosecutorial authority is divided between the Office of Attorney General and the United States Attorney. Our federal counterparts handle sort of the more serious adult felony offenses, where our office, we handle juvenile crime and adult misdemeanors. But look, needless to say, I'd be remiss if I didn't say that, look, while yes, we have a consumer protection mandate, and we're gonna dig into that. I'm very much looking forward to digging into our consumer protection mandate and how we use that to make sure that we hold tech companies liable or responsible for their actions. But it's also really important to note that our office, our independence, and DC statehood is something that's really, really long overdue. We're in a jurisdiction where we've got 700,000 people, 50% of them or so are Black. We've got more people than Wyoming and Vermont. We've got 76,000 small businesses employing about 250,000 people, about 11,000 people in our district serve in the military. And because we're not a state, we lack voting representation in Congress and the ability to fully control what goes on in our city. And so it's a really, statehood is a really, really important thing. And when AG Carl Racine took office in 2014, he made it a priority to build an independent and a robust consumer protection practice and bring creative lawsuits and that would advance the interest, if you will, of vulnerable residents. So for that reason, we're innovating with our legal authority to provide restitution for consumers locally. We're also leading multi-state coalitions, and fortunately, we are winning in those coalitions. We've also pushed the federal government in the right direction on key policy issues, showing that DC, we should be taken seriously alongside with other jurisdictions in the states, frankly. And our office has unquestionably taken on big tech companies like Facebook and Amazon for the harm that they've caused to district consumers. And we'll talk about that in a few minutes. And we don't bring these suits just because there's this fervor, this noise around reining in big tech. We bring these lawsuits because companies are causing real and tangible harm to district residents and also people across the country. So I'm looking forward to digging into these issues with you, Ellen. And again, thank you for having me.
That's great. And it's really interesting to hear about sort of the multiple intersecting agendas that you have to deal with. And so let's talk a little bit about your current ongoing litigation against Facebook. It's against Facebook and Amazon, right? Or is it just?
Yes.
Yeah. You can call them Facebook or Meta, as you
will. Sure. Yeah. So look, I'm happy to start with our lawsuit against Facebook or Meta, if you will. We currently have 2 active matters against Facebook. The first matter relates to what many of us know as the Cambridge Analytica scandal. And we brought this lawsuit alleging that Facebook failed to protect the privacy of its users and deceived users about who had access to their data and how that data was used. And Facebook's lax oversight enabled Cambridge Analytica to acquire about 340,000 district consumers' data. That's more than half of our city's population. And notably, last month, we added Facebook CEO Mark Zuckerberg to the complaint. And this is the first time that a United States regulator, including an attorney general's office, specifically named Mark Zuckerberg in a complaint. And we did our due diligence for sure before taking this really important step. Since we originally filed suit back in December of 2018, we've reviewed hundreds of thousands of pages of documents provided during the course of litigation. We've conducted multiple depositions ranging from Facebook's directors to former employees to whistleblowers. And we've also reviewed documents produced in other cases, as well as countless hours of public statements made by Mark Zuckerberg, including his sworn testimony before the United States Senate and other law enforcement agencies. Based on all of that evidence, based on our review of the discovery, based on all the information that we reviewed over more than 2 years, it's pretty clear. Mark Zuckerberg knowingly and actively participated in the decisions that led to Cambridge Analytica's mass collection of Facebook user data. More specifically, look, Mark Zuckerberg was instrumental in creating policies and procedures that led to that open landscape, if you will, this idea that Facebook users' data should be open. That open landscape, that was Mark Zuckerberg's brainchild. On top of that, he controls 60% of the voting shares at Facebook. He's the co-founder, he's a CEO, member of the board of directors, and he was responsible for the day-to-day actions of the company, and he should be liable for those actions. And some of those actions include actively participating in Facebook's misrepresentation to users about how secure their data was. And that's the crux of the lawsuit there. And the evidence showed that Mark Zuckerberg also participated in misleading government officials about Facebook's role in this scandal. And under these circumstances, adding Mark Zuckerberg to the lawsuit it's unquestionably warranted. And it also should send a message, frankly, to big corporate leaders, not just big tech, but corporate leaders in general, that CEOs, we will hold you accountable for your actions. I mean, look, Cambridge Analytica, they were able to get users' data because of Mr. Zuckerberg's vision for opening up the Facebook platform to third parties. His efforts enabled Cambridge Analytica to abuse their access and take massive amounts of data outside of Facebook through a side door that was basically an open secret, to developers at Facebook alike. And so with this lawsuit, our goal is to hold Mark Zuckerberg accountable for his actions, and frankly, make sure that people, CEOs across the country and leaders, corporate leaders across the country know that in the District of Columbia, we will hold a company responsible. We'll also hold leaders responsible for their actions. And it's not new. We're not just adding Mark Zuckerberg to a complaint because he's Mark Zuckerberg. We regularly hold executives personally liable in a range of cases, ranging from housing cases to wage theft cases. Anytime it's apparent that a leader of a company or organization has been personally involved in decision-making that harms consumers. And I'm happy to go through examples if it will be helpful. But the point is, this is something that we've done on a very regular basis. And here the evidence showed that Mr. Zuckerberg was personally liable. That's why we added him to the complaint.
Yeah, I mean, that is such an interesting move. And we hear a little bit from the administration, just as we're talking about civil liability. We've heard from the administration talk about in criminal liability, white collar cases, that they're going to start focusing more on the C-suite, and yet it remains to be seen whether they will marshal the resources to actually do that. And so here you have, it was really interesting when you said we did our due diligence, and we've got, students in the audience, and I just, am imagining the lawyers you have working for you and the research they had to do to make you comfortable with that decision. And, I'm wondering if you can say anything about sort of the process. The signaling is extremely important, and it's what a lot of people are saying we need more of with respect to power imbalances and tech in particular, that until you get the attention of the C-suite, it's just a lot of apologies and then backtracking. And so if you can say anything more about that, or even how you work with other state AG's offices and in sort of allocating, spreading the work, sharing the work, either in partnership or divvying things up.
Absolutely. And so I'll answer that in two different ways. First, in sort of this specific case, I'll admit it was a massive undertaking led by really talented lawyers, two of which are on the call with us right now. The Deputy Attorney General for our Public Advocacy Division, her name is Kate Konopka. She's a very talented attorney, and she's leading the efforts, or the boots on the ground when it comes to the Facebook matter. And Jimmy Rock he's the assistant deputy in that division, a very strong manager, is personally involved in reviewing hundreds of pages and thousands of pages of depositions. And that's the kind of case where sort of the discovery review, creating a very clear discovery plan at the outset is critical. And Jimmy Rock, I can say, is one of the people in the office that created a very clear discovery plan for not only going through documents, but tagging documents in a way that we had a clear understanding of what we were looking for. And he provided guidance to a few of our newer lawyers, the newer lawyers in the office, to make sure that we had a feel for what Facebook provided, all the information that they've provided in different cases, all the testimony that they've given to different U.S. regulators, including the U.S. Congress. It was a massive undertaking. And when we got to the point where it was pretty clear that Mr. Zuckerberg had participated personally in the decision-making process, it was almost a no-brainer that we do what we would do in any other case. We're not going to treat Mark Zuckerberg any differently than we would treat any other CEO or any other leader of an organization when he or she participates in a personal way in decision-making. Here's a perfect example in a case against Sanford Capital, which is a DC slumlord that forced about 200 tenants to live in just deplorable conditions. We got an injunctive order that said that the head of the company could not do business in the District of Columbia anymore. In a different case, a cash call called Cash Call, that was the name of the company, we had a series of injunctive terms against the owner of the company that victimized more than, it was a debt collection company that victimized more than 1,300 district residents. In yet another case, we had a judgment against Student Aid Center and its owners, a Florida-based company that unlawfully marketed student debt relief services to the District of Columbia residents. Look, so I say this to say, we have done this in multiple cases before, this being holding leaders responsible for their actions in a personal way. Mark Zuckerberg is just another example of a leader of a company that we are holding personally responsible for his actions when it comes to decision-making authority and decision-making that sort of harms district consumers. Now, Ellen, you asked another question, a good question, a related question about how we work with other attorney general offices, and we work with other AG offices on a very, very regular basis. We coordinate with them on a multitude of things. For example, amicus briefs and multi-state litigation. We communicate with them on comment letters and other forms of advocacy. One example is we recently co-led an amicus brief with New York in the Georgia voting rights case. And at this stage in the litigation, this is when Georgia is, of course, trying to get the case dismissed. We've also led a brief with 22 other state attorneys general in support of the United States Department of Justice's lawsuit challenging Georgia's discriminatory voting law. So amicus briefs, as you know, Ellen, play a critical role in helping judges reach a final decision in a case. And so therefore, we either lead amicus briefs if need be, or we'll sign on to them when the outcome of a case could have local importance in the District of Columbia or national importance, or both. Another way that we coordinate with other state attorneys generals is that we work with the National Association of Attorneys General, also known as NAG. And we participate in a few, consumer protection work.
Great name, NAG.
NAG, indeed. Indeed. And we participate in NAG working groups on consumer protection as well. These groups are really important because it enables AG offices to regularly communicate, to keep track of consumer issues that affect specific industries such as privacy or student loan debt and fair lending. So, cooperating with other state AGs really, sort of helps investigations and enforcement actions, which we refer to as multi-state actions. And in the last few years, we've emerged, the DC office has emerged as a national leader in many of these actions. One example is we were one of the lead states in the multi-state action against Equifax that resolved in 2019. And so we really do try to work with our sister states in a multitude of ways, just like I just named right now. And we're grateful for the partnerships that we formed over the course of the last few years.
It's interesting because when you started out talking about statehood, and you don't have to respond to this, but it just seems to me that like part of the agenda and the message here is that, look at us, we act like a state, we walk like a state, we quack like a state.
Yeah. Indeed, all of the above. We lead other states. We've got more people than at least 2 other states. We've got hundreds of thousands of residents. We've got thousands of teachers, thousands of military personnel. We've got a couple 100,000 children. I mean, we are a state. We pay more taxes than other states. We are a state. We should be given statehood for sure. But in the context of consumer protection, we lead in this area, and we lead in other states. And we're grateful for partnering with them, but there's no question that we lead.
Let me ask you, so, there are analogies in other fields to everything that you're doing, including holding executives responsible. And we always have this debate in tech, like, are the harms that we see in tech, are they like other harms, or are they unlike other harms? And I always answer, they're a little bit of both. You can have bias without technology, but often technology will magnify bias and also make it harder to discern because there's no opacity around tech. There's both scale and opacity. That's my answer, but I don't know I'd like to hear how you reflect on, sort of tech as something different, and tech harms and algorithmic harms as something different than other harms when it comes to DC residents, or are they similar?
So you hit the nail on the head, Ellen. It's a little bit of both for sure. I mean, we've got to start with the Civil Rights Bill in the 1960s, right? I mean, look, the authors of those bills in the 60s, they didn't know that machine learning or AI would one day be used as tools of discrimination, but they did know that discrimination rarely announces itself. And today, algorithms really quietly but importantly determine critical outcomes in our day-to-day lives, such as employment, housing, financial aid, who gets what job offer, who gets a callback for a job offer, who gets offered housing, what rate someone is offered when it comes to credit cards, who gets financial aid, much more. And look, algorithmic technology, AI, has a lot of good use. I'm not suggesting that we just throw the baby out with the bathwater. There are some things that are really good about algorithms. They can synthesize a large amount of information and create outputs in a way that human beings without technology couldn't do so quickly. So yes, there are some good uses there, but if left unchecked, right, this is the kind of technology that has the potential to permanently embed bias and discrimination into our society, which leads to greater racial inequity and frankly, leaving our country even more divided. I mean, it's pretty simple, garbage in, garbage out. If you're inputting data into an algorithm that in and of itself comes from a biased source or isn't accurate or has either isn't accurate, is biased, or both, then the outcomes themselves, those outcomes will be biased. And we've got to be clear, we've got to be really critical about monitoring the type of data that is inputted into an algorithm. We also need to make sure that we're monitoring the outputs. What is happening as a result of these algorithms? We can't just say it's a machine, and because it's a machine, it's inherently non-biased or unbiased. That's inaccurate. The information that is put into that machine comes from human beings, and human beings must monitor the outcomes of these algorithms. And we really need to modernize our civil rights laws to account for the real dangers that can be posed by unregulated algorithms. Let me give you a couple of examples there. Tenant screening companies use algorithms to generate automated tenant background reports for 9 out of 10 landlords in the United States. 9 out of 10 landlords are using these tenant screening companies, which use algorithms. These algorithms are prone to errors, including things like inaccurately or incorrectly including a criminal conviction or an eviction record that is tied to someone with a similar name, but it's not the same person. And this technology is especially error-prone and over-policed communities. That's just one example of how we've got to monitor the outputs when it comes to tenant screening companies. Another example is 90% of United States hospitals have developed algorithmic strategies as a part of their business models. One algorithm that is widely used in hospitals, it has been publicly reported that this algorithm is less likely to refer Black patients for care than equally ill white patients with the same problems, which results in 28.8% of Black patients being incorrectly deemed ineligible for additional care. That's another example where we've got to monitor the outputs of these algorithms so that systemic bias doesn't get embedded in who gets what treatment or who gets deemed eligible for what sort of medical health care. Yet another example, Ellen, of how we need to really monitor algorithms is that more than 90% of lending decisions are based on Fico credit scoring. And the most commonly used Fico credit score uses an algorithm that, for example, positively weighs mortgage payments, but excludes rental payment history. Problematic for sure. And that's because we know that Black folks, Latin American folks, Native American folks have historically had less access to traditional credit than white consumers. And so we really need to be laser focused on monitoring the outputs of algorithms so that we're clear on what kind of discriminatory effects are are happening and how we can fix what we can do to fix them. And I think the one first step is being transparent about how algorithms are being used. We need to really ensure that institutions are incentivized to stop discriminatory practices when an algorithm is producing a discriminatory result. And we need to incentivize institutions to be transparent about how algorithms are being used in today's society. So I hope that answers the question, Ellen, about the harm that we can see from algorithms. And again, I don't mean to suggest that they're just useless. They're not useless. We have to monitor them. And if we don't monitor them, we risk falling into the trap that it's a magic box that just outputs non-biased data, which is inaccurate.
Yeah, no, that's great. And I'm so happy that you mentioned transparency because, I'm listening to you talk and I'm thinking about the resources in an AG's office or in any federal agency, sort of, the FTC, for example. And, by the time the discriminatory output bubbles up, knowledge of that bubbles up to your office, there's already been a lot of harm, right? And it's been researchers or journalists who have sort of figured this out. And ideally, one would want kind of more of an ex ante or to have both working together, the ex post enforcement working together with some sort of ex ante regulatory structure, in addition to what you mentioned is new legislation, new civil rights legislation that kind of gets at the harm, codifies the harm in a better way. But so just resting on that ex ante, because I was so intrigued to hear that your office is working on legislation, and I don't know how common that is for your office to work on local legislation. Maybe it is in the district. I'd love to hear about that, and then about this in particular, the algorithmic legislation.
It is. Thanks for the question, Ellen. It is very common for our office to work on legislation alongside with our local council. We try to be partners with our local council, and when we see a problem, we introduce legislation to fix the problem. One example, as you just mentioned, is algorithms. We are working on an algorithmic discrimination bill, and it's not as if we're just working in a vacuum. We've sought input from external stakeholders in the business community to give us an idea of how they're using algorithms and how legislation could impact their business practices, because we don't want to introduce legislation without having a full understanding of what could happen as a result of this legislation. But to give you a very, an overview of what we're considering, we have not introduced the legislation yet, but we are very close to doing so. One piece of the legislation would require a company that is using an algorithm for a life decision, not just any algorithm, but an algorithm that impacts a life decision, where someone's going to live, what kind of interest rate they're going to get, what kind of job offer, are they going to get a call back? These are life decisions. These are really important uses for algorithms. And so a company using an algorithm for such a life decision is required to monitor those algorithms and take a look at what sorts of results are coming out. What are the outputs? If the company finds a discriminatory impact, the company is required to report it to the Office of Attorney General. It's a pretty simple request. We're not, it's not intrusive. We're not asking for, some proprietary information about exactly how the algorithm was created. We're asking for a company to monitor its own algorithms for discriminatory effects. And if they find them, tell us about it. And if you don't, there will be penalties. It's a fairly straightforward analysis. It's a way to make sure that we're protecting district residents, especially when it comes to a life decision. So we're excited about the potential. We're grateful for the partnerships that we have forged along the way, talking to business leaders and frankly, talking to other government regulators as well.
That sounds really interesting and in line with, I think, certainly what's happening in Europe and sort of recommendations for AI regulation, where you've got it's risk-based, right? And so we're talking about the algorithms that have a higher degree of risk of hurting someone in a fundamental way are subject to more scrutiny. It makes a lot of sense.
That's exactly right.
So I want to remind our audience, or maybe I never said it, that you should drop questions if you have them into the Q&A, and we have another 15 minutes and I want to make sure we leave time at the end for questions. And I also usually, Jason, just to warn you, like to kind of spend 5 minutes or so just on your life as a lawyer, your life in the law, and to give, especially because you've had such I think the only thing you haven't done is like been corporate in-house. But sort of coming back to algorithms and algorithmic regulation, I mean, one of the things, and this I guess goes to transparency, is one of the things that sort of concerns me is that right now we're relying a lot on kind of FOIA and journalism and researchers to kind of dig up what government agencies, how they're using algorithms, public bodies, as well as the private sector. And, I'm thinking of one example that was just reported out of the LAPD, and it looks like it was a service that the LAPD was, flirting with or maybe going to use or testing, but now has said it's not using it. But the FOIA request, and this was done out of the Brennan Center at NYU, and having done these FOIA requests, it is absolutely backbreaking work. They did the work and they discovered from the LAPD these kind of marketing materials that the company was using, just flagrantly, sort of predicting who was likely to engage in illegal activity based on their social media profile, and even then tracking the friends of the connections of those people, and so in ways that raise all kinds of flags about profiling and surveillance and invasion of privacy. And so, but what's interesting, but sort of my question goes to, and gets related to transparency and how we get the right data. My concern is that once that's exposed, then whether you're in the private sector or the public sector, and you're procuring this kind of tech, you then know, okay, don't publish that stuff. Like, yes, we know it's going to work that way, but like, we don't want any records about that. And so what worries me is that companies are getting more sophisticated about things that raise red flags. And one would hope that the legislation that you're working on would sort of turn that sophistication to the good, and so that then they would be in a position to monitor and report. But I fear also that it just ends up suppressing, in the same way in the analog world, like you said, discrimination doesn't announce itself, right? People got craftier about how they sort of enacted discriminatory policies. I worry about that in the algorithmic context, and I don't know if you have thoughts about, how we create structures that people can't sort of hide the way that these algorithms are working.
No, I think that's a really good question and a difficult question, because you're right. Look, I think that in general, governments and private industry will evolve for sure. And so I think the first step, and I know that this is a basic step, is trying to ensure transparency. It takes us right back to the beginning. We've got to be transparent about how an algorithm is used. And one part of the bill that I didn't mention earlier is that you've got to notify consumers if an algorithm is being used to create or to determine a life decision, a life decision. So notifying the consumer is one thing, that an algorithm is being used. That's a really important component of the bill. That takes us to transparency. It does not take us all the way, Ellen. I totally agree that businesses can, and governments both can and will get more sophisticated as time moves on. But I think that the very first step is ensuring transparency. The next step is, when there's a problem, you've got to report it, and there's got to be some penalties. There's got to be a penalty for failing to report or failing to appropriately monitor the results of your algorithm and how it's being used. So the potential for penalties is a really important component, which does require a fairly sophisticated Attorney General's office. And thankfully, we've got a pretty sophisticated AG at Cora Racine. We've got a sophisticated DC Council that understands the need for such legislation. So I say that to say it's a good first step, Ellen, but it certainly isn't the end all be all. It's not going to take us all the way, but I think it's a good first step.
So let me pick up on that notification to consumers, because that really is interesting. And I assume your office has a sort of stakeholder and community education arm. And I just wonder, what you've seen about how DC residents understand tech or algorithms and how they would respond to that kind of notification, what it would mean to them.
Such a good question. So I think we are really fortunate in the District of Columbia that we've got a really sophisticated and engaged citizenship. The folks there, here's the best example. When when the district government implemented COVID restrictions, we had an extraordinarily high rate of compliance, which was very helpful. Not the end all be all. We certainly had our fair share and have our fair share of tragedies and deaths when it relates to COVID, but we have an engaged citizenship. And how that relates to sort of algorithms and data privacy, I think that in general, people have a really difficult time understanding what an algorithm is. I have been at conferences with very recently, with really smart lawyers, elected officials, chief deputies around the country that are like, what's this algorithm thing you're talking about? And exactly what is it? I mean, just sort of basically laying out the premise of an algorithm is just sort of a set of rules that produces an output. There are a bunch of this input, there are rules, there's an output or outputs. But really explaining that to people is one of the first steps. I am not convinced that this, just the everyday citizen or the everyday regulator understands exactly what an algorithm is. I am fortunate that I work in a really progressive and thoughtful office where people like Key Konopka and Jimmy Rock educate the community on what algorithms are. And so we do so, but we need to do more, and we can do more, and we should do more. To directly answer your question about how people will respond, I don't know. I am unclear what people will do when they get this information, but they deserve to know. They deserve to have this information, decide for themselves what to do with it. And so it is our job to make sure that companies are informing the general public of sort of what they're doing with algorithms.
Yeah, and I think one of the things we can hope for is that you start with that disclosure, you start sort of supporting an ecosystem of knowledge where, they can be NGOs or like community representatives who can get their arms around, is this an algorithm we like? Is it one that we don't? Is it problematic? And one of the things that concerns me sometimes is that, we can be there's so many problems with this tech that we kind of turn people off of technology when, some of these, some algorithmic processes can make things much fairer, right? And much better.
Sure.
Yeah. So let me, I don't think we have any questions. Let me just ask you one more question before we get to the personal side of this. And that's, it's really about federalism, I guess. I mean, it's really about, what is the role? Industry will say, the last thing we want is a bunch of states telling us different things about what we have to do, right? And at the same time, industry also gets in the way of a federal unified AI regulation or algorithmic accountability regulation. And so I guess, my question is really, what do you think are the costs and benefits of whether we're talking about the ex-ante legislative side or the enforcement side of states taking these matters into their own hands? And I sort of want to just acknowledge that what you've already said, which is that states have always had a law enforcement role with respect to consumer protection, so this is not new. But if we just are looking at it in the tech context, what are the pros and cons?
I think it's a great question. I'll start with Justice Brandeis, right? He said, look, states are the laboratories of democracy. And I completely agree. Given the current log jams in Congress, we need more states to keep leading the way on consumer protections. States are especially stepping up in the privacy space, for example. Back in, I believe it was 2002, California became the first state to require companies to notify consumers when they've suffered a data breach. And many states quickly follow California, building off of building off one another to create more robust and consumer-friendly data breach notification laws. And now all 50 states have such laws. That's an example of sort of states being the laboratories of democracy, and now all 50 states have laws to protect consumers when it comes to data breaches. The same thing is now happening with other privacy legislation. For example, Colorado and Virginia are following California's lead in enacting comprehensive data privacy statutes. That's yet another example. Think back to the 1990s, the tobacco litigation. That's where several state attorneys general managed to reshape one of America's largest industries without the involvement of Congress or the executive branch. And so as tech continues to transform our society, we've got to keep finding areas where Democratic AGs and Republican AGs can come together to stand up for consumers. Because look, protecting consumers is not a red issue, it's not a blue issue. The harmful impacts are felt on consumers nationwide in rural and urban areas alike. And so I think, this is an opportunity to make sure that we have bipartisan support on an issue that impacts bipartisan citizens.
Okay, so just in our last few minutes, Jason, just tell us a little bit about your life in the law. I mean, I see the whole arc. To me, it all seems like public service, one kind or another, but maybe you can talk a little bit about being in and out of the public sector and how you've seen your legal career.
I appreciate the question. Look, I started my legal career as a public defender. I was there for about 8 years. My goal was to fight for people that have the odds stacked against them. And now that I'm at a prosecutor's office on the regulatory side, that mission really hasn't changed. As a public defender, I had the opportunity to impact people's lives one at a time, case by case by case. And sometimes that meant going to trial and winning a case. Other times that meant making sure that someone's voice was heard, that they had someone that was their advocate. And it really meant a lot for me, but it was a case by case basis. Now at OAG, I've got an opportunity to really impact a broad number of people with one action, like enacting legislation or introducing, legislation, or filing a lawsuit against Amazon, for example, that impacts hundreds of thousands of district consumers as opposed to just one consumer. So I really see my role at the Office of Attorney General as a continuation of what I've done for my entire career. I had a stint in private practice. I loved being in private practice. I handled cases oftentimes where my clients were mostly from voiceless communities. And I handled lots of civil rights cases, some police cases, lots of plaintiff side cases. And there, I was able to give a voice to people that historically didn't have a voice. But again, it was on a one-off basis. Now that I'm at OAG, I have an opportunity to really continue that work, but to do so, on a broader scale. And the last thing I'll say is that I really appreciate it really sort of satisfies my intellectual curiosity at OAG. I've been we've got 10 different divisions that have multiple different subdivisions. And so it's never a day where I say, I know this area of law cold. I'm learning every day. And I really appreciate the opportunity to learn. I get to learn from people like Carl Racine on a very regular basis. I get to learn from Jimmy Rock and Kate Kanapka all the time. Kate is an antitrust expert. Jimmy Rock is a consumer protection expert. I've litigated my entire career, but learning these subject matters is awesome. And I really feel fortunate to be around people like Carl and Kate and Jimmy and really the other people in the office, because frankly, it is something that it's a unique moment in time. It's something that I never saw in my future, but I'm really glad that I had the opportunity to do so.
Okay, unmuted. All right, I'm going to ask you a really unfair question as the final question, but for those of our students who want to be you, who want to do what you just said you did, can you give, do you have a couple lines of advice?
Yeah, it's a good question. I think the advice that I would give is be a problem solver, right? And so law school teaches you to identify issues and point out issues. Issue spotting is a really big deal in law school. And the really good lawyers can spot an issue and tell you the issue. The great lawyers come up with solutions to problems. So whatever the problem is, it doesn't have to be a litigation problem. If you really want to be a good lawyer, solve problems, come up with solutions. It is really, I see really good lawyers sometimes that just come to me with problems without solutions. I think identifying a problem is one thing, but come with a proposed solution, and that will set you apart from many of your colleagues. So I think that the advice I have is be a problem solver.
I think that's good advice for everything in life. So
Indeed.
I just want to thank you so much. And we had here also in the presentation, although I don't think our audience can see them, Jimmy Rock and Kate Kanopka. And just want to just express my appreciation for all of the people from the office for this work. And it's a city that I love, the District of Columbia. And so I thank you personally for your work for the DC residents. Thanks for being with us.
Thank you for having me, Ellen. Really appreciate it. Bye now.
Bye-bye.